Welcome to Cordell Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Welcome to our Men's Divorce Podcast. The purpose of the podcast is to educate you on interesting family law topics and not provide legal advice. To obtain legal advice, please set up a consultation with us. To do so, please contact 866-DADS-LAW or visit our website, CordellCordell.com. And you can set that up virtually, in person, so it could be by Zoom, or it can be over the phone. My name is Jerrad Ahrens. I'm a management partner with Cordell Cordell in our Omaha, Nebraska office. And today we will be discussing preparation for testimony and direct examination. This is very important. This could be at trial. This could be at any evidentiary hearing. And it's important to be prepared. And with me today is Jennifer Albano, lead litigator in our Tampa office. She's here to discuss preparing for testimony in court. And with that, one of the first things you want to do is just make sure you know your audience. Is that correct, Jennifer?
Yes, absolutely. So before you attend a hearing, you want to make sure you know who you're going in front of, whether it's going to be a judge, a hearing officer, a general magistrate. In some jurisdictions, they even do jury trials. So that's something you want to make sure that the clients know. And, before going in front of a judge or a magistrate, you want to make sure you know all of their procedures and how they want their courtroom handled.
And what about your surroundings? What do you want your clients to know as far as the surroundings go when they're testifying?
Sure. So you want your client to be familiar with the courtroom. So, because of COVID, there have been a lot of hearings that have been virtual. So some hearings are done via Teams, some are done via Zoom, some are in person. Depending on whether you're in front of a judge or a magistrate, it may be in a courtroom, it may be in judges' chambers. So that's something that you want your clients to know well in advance so that they know what they're walking into and they can be familiar with it. You also want to make sure that your client knows before you attend any hearings what technology is available. So let's say, for example, you've got some evidence that you need the judge to review, maybe a video. You need to know if there are screens available, if you need to get a media cart from the court technology office. You need to know what equipment there is. So those are all things that you would want to make sure that you're aware of before having a hearing. And additionally, if you're going to be using Zoom or if you're going to be using Teams, you want to make sure that you practice in advance of any hearing. So I've got a lot of clients who haven't had to use these applications before. And so before any hearing, I get on Teams or Zoom with my client and walk them through how to log on, how to go to the website, how to put in the meeting ID, how to make sure their microphone is working or their camera is working, make sure they're in good lighting, all of those types of things. So those are some really important things to know about your surroundings. In addition to that, any technology that you're going to have to use in a courtroom, you want to practice that in advance.
Right. It's important to do that because you don't want to waste valuable time, correct? You've only got so much time to testify and get your case before the judge. And I've experienced on too many occasions where there's technology issues and it's cut into your time. It's led to maybe continuances or you've had to shorten up your testimony. So like you said, it's very important to test that out and be prepared to be ready to go. Talk about knowing your enemy when testifying at trial.
Sure. So before trial, you always want to assess the other side's case. The more you can deflect and diminish opposing parties' strengths, the better you're going to be. You also want to make sure you're not going to be surprised by any evidence that's presented at trial. So, a way to learn what the other side is going to present, in addition to just regular discovery, depositions, filing a request to produce to get documentation from the other side. You can also sometimes get useful information in either a mediation or a settlement conference. Sometimes opposing counsel, when trying to settle a case, will give away some valuable information that you didn't necessarily know. So you want to pay attention to all the information that you get from the other side, not necessarily just informal discovery. You also may want to assess the other side's personality. So, that may not be something that a party would think is important before going to trial, but, every judge, every general magistrate is going to be different. They handle their courtrooms differently, and certain judges don't like when, an attorney acts a certain way or when a party acts a certain way in court. There are some attorneys that get up there and they want to put on a big show and want to be aggressive with clients. There's a lot of judges that don't like that. There are some younger attorneys who may be a little bit more inexperienced and don't necessarily know the rules of evidence as well. You might be able to get away with a little bit more if you're working with, somebody who hasn't been practicing as long. So in addition to knowing the parties' personalities, you also want to know the opposing counsel's personality. If you've got a party who is very aggressive, that's not necessarily going to come off well on the witness stand, especially depending on your judge or magistrate. So those are some important things to consider when you're assessing the other side's case as well.
And I've found over the years that when picking out an attorney, it is extremely important for that attorney to know that particular judge or those counties and opposing counsels. I think it's just as important as knowing the law, knowing how to work a case, as knowing your judge, how they handle the courtroom, and how those opposing counsels handle their negotiations, how they handle hearings, trials, and things of that nature. I think it's very important. So you have a game plan going in as to how this is going to work with these particular parties and characters involved in the hearing. Talk about knowing yourself as a client and knowing in your witnesses that you're going to present at the hearing.
Sure. So, as the client, you want to make sure you're managing your emotions. You want to make sure you know what your witnesses' emotions are going to be, what they're going to testify to. So, for example, let's say we're representing a husband in a case and their parents are going to be testifying at trial. Well, do they hate the wife? Do they have an issue with the wife? Are they going to come across as angry, trying to punish the wife in their testimony? Or are they going to be more genuine and, talk about some of the pros and cons of mom? So you've got to be careful who you're putting on the stand as a witness, because you don't want their testimony to come off as disingenuous. As a client, you also have to check your emotions. A lot of times clients will come in here and they're angry. Maybe there was infidelity and, they get up on the stand and they're very upset. I've got clients who don't necessarily want the divorce. And so that can taint their testimony because they may not want to say, anything bad about their soon-to-be ex-spouse in hopes that they're going to reconcile. And that could ultimately hurt their case at trial. So those are some things that the client has to think about before getting up on the stand. And additionally, as a client, the client has to manage their expectations. The attorneys have to help the clients do that as well. So as an attorney, I always sit down with my clients to discuss their expectations of what it is they're expecting out of the trial. Sometimes we don't have the best facts. Sometimes my client's done something wrong. I'll have to sit down and explain to my client, hey, we don't have the best facts. We may not win on every single issue at trial. I'm certainly going to prepare and argue for my client, but I want them to understand that sometimes the law may not be on their side. Clients also have to understand that how they testify at trial is going to affect the outcome of the case. So as the client, they're the ones that are going to be doing the heavy lifting. They're putting on all the testimony. As the attorney, we don't get to present the testimony to the court. We can ask the clients questions, but they're the ones that have to provide all the information. So really, preparation for trial is so important. And as the attorney, we set several appointments before any trial to get the client prepared and practice their testimony so that they're familiar with exactly what we're going to be asking them at trial.
Yeah, something you just touched on was expectations. That's something I kind of learned the hard way as a young attorney. I would tell clients what they wanted to hear initially, and a lot of times it wouldn't end well. And so as I got more experienced, it was from the onset of the case, I would set those expectations with clients right away. So they had an idea of what this was going to look like, a realistic way of looking at it rather than, all sunshines and rainbows. And that goes into prior to a hearing too, and testifying before a hearing or in a hearing. So you talk about preparations. Now let's focus more on and get more details on preparation for testifying.
Sure. So, the first thing I want to do is I want to educate my client. I want to, first things first, identify the legal issues in a case. So I want to make sure my client knows exactly what issues we're going to be litigating. Is this a trial just about child support? Is this a full-blown divorce? Are we going to be covering, time sharing, child support, equitable distribution? So I want to make sure that the clients know exactly what's going to be heard. And then I want to make sure that I identify the applicable law as it relates to each of the issues. And so all of the attorneys at Cordell before trial and early in the case, we send all of our clients a legal issue letter, and it actually lays out the applicable law for every single issue in that client's case. I always tell my clients to review it in advance of mediation, in advance of any temporary hearing, and in advance of any trial so that they have a full understanding of what the law is as it relates to their case. And then I also want to educate the client about identifying the legal process. So I want them to know exactly what the litigation process looks like. That's actually another letter that all attorneys in Cordell are going to send their clients. We want the clients to know exactly what they will expect in this particular case. So in a divorce, I'll sit down and explain to the clients, we've got the pleadings, and this is what that looks like. The next step is discovery. The next step is mediation, and we lay it all out so that they have a full understanding. In addition to that, I want them to know what to expect in court. I want them to know where they need to sit, who's going to be in the courtroom, how the hearing is going to be proceeding, what they need to wear, how they need to behave. And so at any preparation appointment with my client for a trial or a hearing, I'm going to sit down and go over those important things with them. Now, as it relates to preparing for trial, again, I said first thing I'm going to do is educate them. Next steps, we want to start getting prepared. So something that I do in most of my cases is I try and come up with a theme for my trial. So I always do an opening statement before trial, and I know that's not the case in every single jurisdiction, but I would assume most. And so when I'm doing an opening, I want to kind of come up with a theme and tie it in through my opening and all of my questions. And that's something I'm going to sit down and go over with my client. I've had in some cases, let's say, for example, I have a client in the military. I may want to make my theme duty and order. My client as a member of the military, follows duty and is always following orders. He's done the same in the divorce. He's done the same throughout the marriage. Whereas mom, on the other hand, has failed to follow court orders and there's no stability. So that may be a theme I want to tie in. I also want the clients to be fully aware of the rules of evidence. Not 100%, that's my job, but I want them to at least understand, what testimony is allowed, when they're testifying, what they're going to be able to testify to. If they do testify to certain things, they may get an objection from opposing counsel. So, for example, parties are not allowed to testify to a hearsay statement, an out-of-court statement that somebody else has made. The parties are only allowed to testify to what the other party has said. Our clients can't testify to what the children have said. So I want my clients to understand what testimony is and isn't allowed and what to expect if they do testify to something they're not supposed to.
Something else when it comes to rules of evidence and direct examination that I think is important for clients to realize is we can't ask leading questions. We can't spoon feed them. That's why the preparation is so important, right? Because they've got to know. So you're going to have to give thoughtful and detailed answers because we can't ask you leading questions. Can you talk more a little bit about when you can and cannot ask leading questions?
Sure. So on direct examination, that's when I'm calling my client to the stand to put my case in chief on. And so when I'm calling my client on direct examination, I'm wanting them to provide me a narrative. That's where they're telling their story to the judge. That's where they're giving the court all the information the judge needs to know to rule in their favor. Now, on the other hand, when opposing counsel is asking them questions on cross-examination, that's typically when you're going to get what's called a leading question, or a question that can be answered with a yes or a no. And oftentimes I tell my clients when they're on cross-examination, always answer the question with a yes or a no. If you need to explain your answer, try and do so. You may get an objection from opposing counsel. They may not want you to say anything other than yes or no. If the judge holds a client to the yes or no, then I can call them on what's called redirect. And on redirect, I can ask them and say, hey, I heard in cross-examination, opposing counsel asked you ABC and you said no. Did you want to explain your answer? And then at that point, again, the client's able to provide a narrative response where they're giving me, kind of the full story instead of just a yes or a no answer. And so that's something that I'll always go over with my client when preparing. I'll prepare for direct examination and I'll walk them through all my questions. We'll practice answers, what kind of information the court needs. And then oftentimes I'll even bring in another attorney to practice cross on the client so that they know what to expect. I certainly can't say with any 100% certainty what opposing counsel is going to ask on cross-examination, but oftentimes we have a pretty good idea, and so we can prepare them for any possible weaknesses in their case.
Yeah, no, I think that's very important to let the client know, hey, look, on cross-examination, you're going to get frustrated. You're not going to be able to say everything you're going to want to say, but we're going to have that opportunity on redirect for you to say, like you said, your narrative. Because I've seen it too many times where clients get very frustrated because they get cut off. They want to explain their yes or their no. It's kind of like the opposing counsel is making it sound like it's a gotcha moment, but it's really not. And so remain calm, cool, and collected, and you'll get your opportunity to discuss that in more detail on redirect. Talk a little bit about exhibits and evidence and how we prepare to submit those in court.
Sure. So, anytime we need to have exhibits put into evidence at trial, I have my clients send them to me well in advance so that I can make sure I can make my exhibit deadline. But when they come into practice, their direct and their cross-examinations, I have all of the exhibits ready to go. I have them in a book in front of my client, and I have them in a book in front of myself. And I go through each and every single exhibit with my client during testimony because I want to make sure that they're fully aware of every document that I'm going to be presenting to the court. And I want them to understand what questions I have to ask to gain admissibility of that evidence. So that's what we call foundation. And so I walk them through all of the foundation questions, which are essentially questions to authenticate the document. And I'll sit there and explain to the client why I'm asking all of these questions, because they're not questions that one would typically think I would ask about a document. So I'll explain all of that. And then, I have the client explain to me what each and every document is. And I go over those documents with the client multiple times. And the reason I do that is because when we get to trial, the client needs to be so familiar with everything that's going in. Because if a client doesn't remember the exhibits during testimony, it'll take valuable time away from the trial. So if the client has to sit there and look at the document and I have to refresh their recollection, sometimes the client will sit there and look at, a document for 5 minutes. Well, that's 5 minutes we've just lost out of our, 4-hour hearing. And if that happens 10 times, we've lost a significant amount of time. So really practice, and review is so important before attending a trial, especially if it's heavy with exhibits.
And you might lose some credibility, right? When you're not remembering things or not familiar with the exhibits. It might impact credibility negatively when testifying in court. The golden rule, direct examination. This is a good one. I wish I would have learned it earlier. I think it wasn't so much on direct examination, but it bit me on cross one time pretty bad, and I will never forget it. So let's talk about the golden rule.
Sure. The golden rule is you never ask a question that you don't already know the answer to. And it's so important. And that's really the main purpose of discovery in a case. So, the clients are always like, okay, why does it take so long from filing a case to getting in front of a judge for trial? And a lot of the reason is because we have to do our due diligence to make sure that we know all the facts about your case, that we know everything that your, soon-to-be ex-wife is going to testify to. So if we go into court and ask a bunch of questions and we don't know what she's going to say, there may be a bad fact that comes out that we're not necessarily prepared to defend. And that could put the client at, a disadvantage. And so preparation is so important, and making sure that you have your questions written out and that you don't just throw questions at the wall because you don't want something to harm your client at the end of the day.
And I think that's why discovery is so important in cases. Sometimes people want to cut corners and maybe not do as much discovery as you could. It can be burdensome. It can be expensive, particularly depositions. You can go in there in a deposition and ask all kinds of questions, and you're going to learn the answers right before trial. So you're going to know what not to ask and what to ask at trial. I think it's a valuable tool that I think is underutilized a lot of times. So I'm a proponent of depositions because that way you're going to know the answer to questions you're going to ask at trial. And if for whatever reason that witness, whether it's our client or some other client or another party, answers differently, well, we've got the under oath deposition transcript to impeach them on the stand from something they would have answered differently at the time. So that is it for today. Reminder to set up a consult with us. Please call 866-DAZLA or visit our website, CordellCordell.com. Thank you.